let us move on to mediation under section 89. So, mediation is based upon the rules established by the court under civil procedure alternative resolution rules 2006. These rules prescribe the procedure to be followed by the mediator. Now, first let me talk about the role of the court in mediation process. So, if the parties unanimously decide that they want to go for mediation, the court is bound to refer them for mediation. They will make an application to the court, and based on the application they would be referred to them. But if there is no unanimity, if there is non-response from the other party, then there would be an application to the court stating that the other party is not responding. What to do? So, then the court would issue a notice stating that the other party is thinking of mediation, what is your answer to this? In that, if the response is positive, matter will go to mediator, but if the response is not given, then court would make a decision, because now the ball would fall into the court. Then if there is no unanimity, then again the court takes up the decision making power, and they would send the parties to the mediator or judicial settlement, whatever the court feels fit. Then there is a specific bar that court cannot send every and any dispute to mediator or ADRS, like a case where next friend is representing instead of the party himself, maybe because the party is minor, or maybe the party is disabled or is insane. So, these people cannot go for mediation negotiation, and in representative suit again they cannot go for mediation and negotiation, because it is not supposed to be settled by the court. So, even though these are exceptions, court can overrule these exceptions by exercising veto, because if the court feels that they can protect the interest of the minor in the whole process, they can ask the guardian to negotiate and settle the dispute. So, now again continuing with the role of the court, the power to refer is exercised with the consent of the parties, but the power to refer also comes with power to review. So, they can review the reference of a dispute, or they can review the non-reference of the dispute. They also enjoy the power to withdraw the reference. They also enjoy the power to prepare the panel of mediators, so to whom the parties can refer the dispute. Then very importantly, they also enjoy the power to remove and delete. When I say remove, I am talking about a mediator who has certain interest in the outcome of the case, he would be removed and replaced. Delete is when a mediator is found to be inefficient, ineffective, he would be removed or deleted from the panel of our mediators. So, that is deleting. So, removing is from one mediation process, but putting him in another mediation process, but deleting is removing him from the mediation activities altogether. So, then the appointment of the mediator is done again by the parties if there is unanimity. In case of lack of unanimity, court steps in and they adopt direct and indirect process. In indirect process, the parties will appoint one mediator each, and the mediators would appoint the sole mediator, that would be the mediator who is going to handle the matter. So, indirectly parties are making an appointment because of lack of unanimity. Then freedom of selection, parties can select mediator from the list available, or they can go beyond the list and select anybody they want. So, they have a complete freedom in selecting the mediator. Qualifications of mediator, interestingly, if you look at the list, they talk about retired judges of Supreme Court, High Court, District Court, Civil Court. They talk about lawyer with 15 years of experience. They talk about retired senior bureaucrats. So, if you look at this list, I find that the role of the mediator is not to decide, role of the mediator is to facilitate, role of the mediator is to encourage. But these people, the list that is given I find that they are not very suited to mediation, they are very suitable for arbitration. But other than this, there are experts of our other professionals, there are expert institutions who can act as mediators. I find they are more suitable to it. So, the reason why I am saying that they are not suitable is because the way they have led their life as a deciding authority, now they cannot decide, they only facilitate. That would be a little difficult to adopt. Disqualification. Who cannot be mediator are the people who are insolvent, unsound mind, who are having criminal charges of crimes involving moral turpitude, disciplinary proceedings pending, are charged or even convicted. Interested people cannot be mediators. Legal practitioner who has represented any of the parties or representing any of the parties cannot be mediator, or any other disqualifications as notified by the High Court. So, these are the qualifications, disqualifications. Now, coming to the role of the mediator. So, first role is expressing his independence and impartiality by communicating to the parties that he is completely independent and impartial. If there are any circumstances which gives rise to doubts as to his independence and impartiality, must be communicated in writing immediately, and this duty to communicate operates beginning till the end of the mediation process. Then he is supposed to facilitate voluntary resolution of dispute, and is supposed to develop efficient communicating process between the parties. As I already mentioned, the role of the mediator includes identifying of issues, reducing the misunderstanding, clarifying priorities, exploring the options to resolve the dispute, and he should keep on emphasizing that it is the parties who are supposed to decide and resolve the dispute rather than mediator suggesting it. There are ethical issues which the mediator should address, that is, he cannot behave unbecoming of mediator, integrity and fairness should be shown, fair communication, adequate understanding of the procedure should be shown as well as communicated, qualification and professional approach should be adopted, adhered to, and justifiable doubts and of independence and impartiality should be communicated without delay. The appearance, communication should not be improper, trust and confidentiality should be shown and he should remain faithful to it, conduct the proceedings according to law, and the principles of self determination should be upheld by the mediator and should avoid suggesting or deciding for the parties, and reasonable expectations should be communicated, and you should refrain from making promises that he is going to resolve the dispute, he is going to get maximum for the parties. Such promises should not be made. So, procedure of mediation, as I said, time, place, date, everything would be fixed by the parties, but if parties fail to come to a conclusion on that, parties would decide for the mediators. So, once the mediation is completed, then comes the issue of settlement of the dispute. So, when we talk about settlement of the dispute, there are two issues in this. One, during negotiation process, mediator is supposed to contact the court or not. The answer is no. He is not supposed to contact the court because it is a confidential process and he is supposed to keep it very secret. So, therefore, communication should be limited to failure of the party to appear, why he did not appear, that can be communicated to the court. If the mediator finds that the dispute cannot be settled because of it is unsuitable for settlement, that could be communicated. Settlement arrived at, communicate the settlement agreement to the court, or any other thing you want to communicate, the mediator is supposed to take the consent of the parties and communicate. So, when you go for mediation, two things are possible: successful, unsuccessful. When it is successful, you draft it into writing, the agreement, attest it with the party's signature, attest it with the advocate's signature, write a covering letter, and the covering letter with the signature of the mediator, it is sent to the court. But if mediation fails, then the report should be submitted that the mediation has failed, but the report should not contain as to why it failed, how the parties behaved, and what is the reason for the failure. Nothing should be communicated to the judge to prejudice the judge against any of the parties. So, these are the two things that needs to be communicated. So, this is brief discussion on mediation and negotiation as an informal process of justice. I am going to discuss the other two, one, that is conciliation and arbitration, in the next chapter. Thank you very much.